All right, well, let's go ahead and get things started. For those that have just joined, thank you for joining us for the April 13th Lunch and Learn for our home-based businesses. This is actually the first Lunch and Learn of our 2022 Lunch and Learn series. York County is the host for this particular one. We are really excited to be able to continue to bring you this Lunch and Learn series in a video format, the webinar format. It is a webinar, so know that if you are an attendee, we will not be able to see you. So feel free to go ahead and enjoy your lunch or anything along those lines while you're participating and listening along. If you have any questions, we're going to hold the questions pretty much till the end, but you can ask them at any time. You can put them into the Q&A box that's there near the top of your screen. And then when we open it up for additional Q&A, if it's something where you would actually like to ask your question verbally, you can raise your hand and we can give you the permission there to go ahead and ask the question for that. The Home-Based Business Network and this Lunch and Learn series is actually sponsored by several localities, and the series will rotate among those of us that are involved. So it's York County, Williamsburg, James City County, Hampton, Gloucester County, Poquoson, and Newport News. And we also have great partners with our chambers of commerce that are here working with us locally. Encourage you to get plugged in with them as well. Just know that all of us in different economic development locality offices are here to assist you, no matter whether you are a brick and mortar business or whether you're a home-based business. Feel free to reach out to us, and if you're not sure how to get in touch with us, feel free to visit our website, which we'll mention here at the end, because all of our information is located on there as well. So to kick off this series, the first thing we're going to have is this session is going to be about understanding contracts. We are very pleased to be joined by Jamie Shoemaker Jr., who is a partner with Patten, Wornom, Hatten Diamonstein. Jamie has had a very long career with them, has been recognized on a national basis, I think since 2006, as best lawyers in America, has been recognized several times by Virginia Business Magazine as one of Virginia's legal elites, has worked in a number of different, on a number of different cases, and really just brings a lot of experience in this realm to us. Jamie attended VMI on a Navy ROTC scholarship, graduated with a Bachelor of Arts in Economics, and following that, he served 4 years as a naval officer on active duty and 3 years in reserve. So Jamie, thank you for your service for sure. He followed up his education at VMI with education at University of Richmond in the T.C. Williams School of Law, where he received his Juris Doctor, and he is has his full privileges with the Virginia Bar. So with that introduction in place, I am going to stop sharing my screen, and we're going to turn this over, and I'm going to let Jamie go ahead and start sharing. So Jamie, thanks again for being with us, and we look forward to hearing what you have to share with us today.
Great. Well, thank you, Matt. Great to be with you all today for lunch. Matt, something just happened on my screen. You hear me okay?
Yes, we still got you okay.
Great. Okay, great. I want to begin by talking about sort of a little bit about human nature and about why contracts are so needed and so important. And I'll do that by relating a discussion I had with a very old friend not very long ago. I've known her since second grade. We go to the same church together. We've never had a tense word in those, whatever, 40 some years, 50 some years. But I made the remark to her that I was optimistic, and that was evidenced by the fact that I believe that only 49% of our fellow human beings who walk the earth with us are capable of a significant act of dishonesty. And she got very upset with me. I mean, very upset, and asked me how I could be so jaded as to believe that so many people who walk the earth with us are capable of a significant act of dishonesty. And well, you know, maybe I am jaded, but it comes from 30 years of practice in law, almost 31 years of practice in law. And maybe the number is a little high, but I doubt it could be lower than somewhere in the 30-ish% range. And, you know, it's been my experience that human nature is such that when there is a lot on the line, it doesn't matter what walk of life you come from, how well educated you are. I mean, that there are people in all of those groups who are willing to lie. There's a Russian author, I think it was Solzhenitsyn, who said something like, the line between good and evil runs through the heart of every man. And, you know, my experience taking depositions, for instance, for 30 years, whether they're CEOs or laborers or professionals like physicians, when stakes are high, a surprising number of people will lie. And that realization, I don't know, kind of, I think it's important for you to understand that, especially if we have folks who are just, you know, entering the business world, who are just getting out of school, who are just becoming entrepreneurs. You've got to be very wary of who you're dealing with. And when we wind this up at the end, I'm going to talk to you about some methods for doing that. The one great thing about capitalism is that trust isn't just good from the standpoint of basic morals and ethics. Value ultimately is assigned to trust. You know, in a community like ours, Hampton Roads, among lawyers, surprisingly, I think the vast majority of my colleagues in the Hampton Roads Bar are honest. In addition to being required to be honest by the bar and by morals and ethics, it's good business, because eventually, and again, getting back to one great thing about capitalism, your reputation matters. So if you are honest, you'll get a reputation for that. And our system assigns it not just, you know, non-monetary value, but over time, real value. The other great thing about a republic that is capitalist is that our rule of law, contracts, help us ensure that people are fair and honest. They're designed and intended to strengthen trust. And so there's some basic rules about contracts to that end, that one of which they need to be clear, they need to be simple, that are very important. And I'm gonna get into those with you here in just a second. You know, another way of kind of trying to convey this issue about trust and about the being wary of who you're doing business with and the propensity of people to lie when the stakes are high, there would be no need for lawyers if everyone was honest. The only reason lawyers exist is because human beings have a tendency to lie when the stakes are high. Now, I'm not saying the majority of people do that. Again, in my experience, it's somewhere in the 30 to 49% range. And contracts will protect you, if they're done correctly, from dealing with folks who are unethical and are willing to lie. So what is a contract? A contract is simply a mutual agreement. It's mutual assent. And it's expressed by an offer, acceptance, adequate consideration, capacity, and they have to be lawful. So let me take those one at a time. I think we all know what an offer is. An offer is person A says to person B, I'm willing to provide you with some service or pay you something in return for something. And person two accepts. At that point, when you have the offer and the acceptance, you have one element that's critical to forming a contract. The other thing you need is adequate consideration. Consideration is value that's exchanged in return for the other person's performance. It can be money, it can be service, it can be a good. But there has to be some value exchanged in order to have a contract. If you agree with somebody that, hey, I'm gonna come over next Thursday and mow your lawn, and they say, great. If it's not supported by consideration, it's not binding. So you've got to be sure that a contract is supported by consideration. You've got to be sure that you're dealing with a counterparty, an opposing party that has capacity. You know, in our society, there's an increasing danger there, especially for real small businesses. You could be on the phone or having an email exchange with a stroke victim, and that person may not have capacity. And you enter a deal you think is great, but you have but you can be unaware that they have capacity. You don't need a legal adjudication for someone not to have capacity. They can be rendered incapable of entering the contract by some medical condition, some injury, or something similar. The contract has to be legal. If the contract does not have a lawful purpose, it is not enforceable. Contracts need to be clear. And I'll get into that again here in a second. There is a rule in Virginia and in most states called the statute of frauds. And that says that a contract can be oral. It's often not advisable that you enter into oral contracts, but a contract can be oral so long as it does not deal with real estate, the purchase or sale of real estate, so long as the performance can take place within 1 year, and so long as it is not for goods for sale in a value of $500 or more, and it's not a promise to answer for debt or to indemnify someone. If in those situations, when you're dealing with the purchase or sale of real estate, indemnifying someone, the purchase of goods over $500, in Virginia, those contracts need to be in writing to be enforceable. But outside of those areas, it's perfectly legal to have an oral contract. Now, why is it advisable for, when you're dealing in a contract that's highly valuable, you're entering a relationship or an agreement that involves a significant exchange of value, it's obviously better to have that agreement reduced to writing to protect the parties. Because recurring back to my concern about the honesty out in the general public and people you're dealing with, it's much better and it's safer to have the agreement reduced to writing in almost all circumstances when you're dealing with significant value. Signatures. The Virginia electronic signature statute says this. It's kind of unusual. It says that the Virginia law defines an electronic signature to include an electronic sound, symbol, process, and any of those things just need to be affiliated with a document made by a person who says that's their signature. I remember a theoretical discussion in law school, not a very practical discussion, but lots of discussions in law school are not practical. But I remember a discussion about the definition of a signature. What is a signature? Well, even at common law in Virginia, a signature is anything a person intends it to be. And I remember in one lesson, the professor pointing to something in the room. I think it was a paperweight or something on his desk. And he said, that could be my signature. And theoretically, that's all very nice, but it doesn't make a whole lot of sense when it comes time for you to have to prove an agreement and that prove that someone agreed to something. While it's theoretically possible to have anything be your signature, I would stick to things pretty basic. If it's not going to be a wet signature and an actual signature, then it needs to be something that looks like a signature electronically, in my view. This idea that you could attach a tape recording to your signature line and have that be your signature, while that is legal technically, I personally don't think is a very good idea. But generally, a writing, if you seek to enforce the writing, needs to be signed. Now, it doesn't have to be prepared by a lawyer. It doesn't even have to be all that formal. It can be extremely simple. Some of the best contracts are, and I'll bet many of you have entered deals where you reach a binding agreement through email, and it perhaps follows a phone call. And that's fine. That can be done. You send out an email to your counterparty or the opposite number in the contractual relationship, and they respond to it, agreed, you've got a deal. Your email exchange needs to be clear, though, and it needs to address the material terms of the contract. If a material term of the contract is unaddressed, whether it's oral or written, if you think you've entered a contract, but there's a material term that's been omitted, then you don't have a contract. So, I think it's, if you have an email, and I've written one out here, and I'm just going to read it, that I think is a good, sound example of an email that would be binding, and is also simple. And this is in my little hypothetical here. This is a situation where there's been a discussion about the purchase of 600 widgets on one morning, and the purchaser then writes this email to the seller of the widgets. We have agreed in our telephone conversation this morning that you will deliver to me at whatever address you want to put there, but it's wise to put an address within 30 days of today's date, 600 widgets for $1 per widget, as long as I pay you within 10 days of the date of this email. And if they respond to that, yes, agreed, you've got an agreement that is binding and, I believe, readily provable. I think that agreement is just as sound as if you had paid some 500 lawyer firm $10,000 to write it. Now, what could go wrong in this example? It's conceivable that you could have a disagreement as to what a widget is. So you need to make sure that, in this example, whatever you're purchasing is clearly defined. And, I'm sure that you all engage in a myriad businesses of all different kinds. And so it's hard for me to get into your shoes and give you an example that would apply across the board here. But you want to be sure that your email exchange or contract, if you draw it up, clearly defines the subject of the contract, whether it's services or whether it's widgets. Now, when you start talking about services, that can get tricky, but that too doesn't have to be complicated. There may be some consultants in the group here. You may have a letter that describes the consulting services that you provide. You might attach your CV, your resume. And if you reasonably describe what you're offering, your hourly rate, and that you'll be paid within such and such an amount of time, and they agree to that, say that we put that in an email exchange, that as well could be binding. So, lawyers can gum up simple deals, and you've got to be, it's an art, I think, more than a science, knowing when you need to get a lawyer involved in a simple transaction and when you don't need to get a lawyer involved in a simple transaction. Probably a good rule of thumb is if you're talking about something that to you is a very significant value, you probably want to get a lawyer to at least take a look at the communications that are going back and forth, or perhaps even retain a lawyer to draft it. And this is also, trust kind of comes into this as well. Here I am giving a talk on contracts, but I will bet you that the Virginia State Bar says it's prudent to have a contract with your client. But the fact of the matter is, I've had some clients for 30 years. I've never had a contract with them. Do work for them all the time. Never had a contract with them. And probably most of my clients that I've had over 10 years are that way. it kind of goes back to this issue of trust. They trust me, I trust them. And so, I'm not saying you've got to have an exchange, a writing every time, but especially when you don't know who you're dealing with, it's prudent. When sometimes when we get new folks in the office, in fact, almost every time when we have a new client, I do enter agreements with them. But if I don't know anything about them, if I know a lot about them, I may not. So that's a judgment call, and I would just say err on the side of caution. A lot of you are probably reaching business agreements over the internet, through email, or by telephone. And you may have had someone say, and I'm hearing about this more and more, although it's certainly not common. You may have someone say, hey, we've just described this deal. Do you mind if we quickly record our arrangement? I suppose that can work. I don't have a visceral or a automatic objection to that, but I would again apply the rule about how significant is the deal, and judge it by the circumstances. But that could work to prove the deal. There's something called the parole evidence rule, and I'm getting kind of technical here when it comes to contracts. But if a contract is found to be ambiguous, or a term is difficult to define, very often the courts will allow evidence about the negotiations leading up to the contract in order to prove the terms of the contract. But that will only happen when there is an ambiguity in the contract. So you'll very often see litigation involving contracts where the parties go back and they talk about, even though there's a writing, they talk about what they agreed to. I'm sure that hiring lawyers reduces the odds that you're going to have to resort to evidence to prove your contract. I'm sure that's the case. You're just going to have to weigh, as you do business, how much you trust the other side, what's at stake, what the value is of the deals you're entering, and whether or not you need to reduce something to a formal writing that's reviewed by a lawyer or not. Almost all litigation of contracts deals with either contracts that were completely oral or contracts that were written that involved ambiguous terms. Because when the court recognizes an ambiguity, the court can then accept evidence on what the meaning of the contract is. If the court finds that the contract is clear and unambiguous, then the contract speaks for itself, and no evidence is going to be admissible with respect to the terms of the contract, generally speaking. So a lot of this, I'm speaking in broad generalities, but that's kind of the lay of the land on the issue of parole evidence and proving up contracts. I am surprised constantly how thin some written contracts provided by major complex corporations can be. I was just reviewing one the other day that major corporation sent my client a contract, and there was no consideration in it. The thing had no consideration. Now, they realized it later and proposed an addendum to the contract, fixing it. But it's remarkable how often I see contracts that are being exchanged, often by sophisticated organizations, that if they've had a lawyer look at it, it's been a long time ago. They had some boilerplate document that they're still using, and it's either ambiguous or it leaves out a material term. And in those cases, they can be, in the latter case, they'll be unenforceable. In the former case, the ambiguity may have to be litigated to determine what the party's intent was. The party's intent is always the goal of the fact finder. In the case of litigation, it'll be the goal of the judge or the jury. But in your case, when you're forming an agreement, it's your job to make sure that you've expressed your intent and you've captured the intent of the other side. And that intent should be mutual assent. So the intent should line up. Your intent should be clear. The intent of both parties should be clear based on either the email communication you've had, the document you come up with. A few things that that you really need to be concerned about. First, don't be afraid to pen and ink a change to a contract. At least propose a pen and ink change. If you get some form contract, even from a big organization, and there's a term you don't like, you can line it out, write in the corrected language, initial it. That can be enforceable as long as it's clear and you haven't created an ambiguity by doing that. Now, lots of big companies will say, this is our deal, we never change it. And you've got to weigh that. Some are telling the truth, some are not. So you just have to weigh that. When you get the contract, you need to weigh whether or not you want to try to propose a change when you're dealing with a larger organization. With the smaller organizations, they're going to be more likely to accept a change or to negotiate a new document. But you shouldn't let anybody just ramrod a writing on you that you're not comfortable with. You can push back. You got to weigh the deal. You got to weigh, what's in it for you and how important it is to you. But I think you'd be surprised by the number of times you can get provisions of even what appears to be a boilerplate document negotiated. In 2022, there really is no such thing as something that has to be boilerplate anymore. It is very easy to get, in terms of the mechanics of it. Now, and it may not be easy to get someone to agree to your terms, but in terms of changing the contract in 2022, that's very easy to do. So you shouldn't be told, you shouldn't accept that, hey, we're not changing the deal, without at least attempting to change it if the change is important to you. Be very wary of one-way fee provisions. You may have already run across contracts that will say, if there's a breach of this contract and we litigate, then side A gets their legal fees. We will get our legal fees if we prevail. But it's silent as to whether you get your legal fees if you prevail. If you enter an agreement like that, first of all, even if it's a big corporation, generally their in-house counsel is going to see the fairness of that. And if there's a provision they're most likely to yield on, that would be one of them. But you need to be extremely wary of entering a deal like that, because then if you ultimately litigate, you are at a great disadvantage, especially if your capitalization level is relatively low. And litigation costs you simply can't afford. So beware of one-way fee provisions. Finally, I think I'm already out of time here, but finally, counterparty risk of dealing with liars and cheats and dishonest people. There are lots of sources out there now to make sure that the other side you're dealing with is legit. The old go-tos are the Better Business Bureau and Dun & Bradstreet, but there are others, checker.com, allininfosearch.com. There's several. So be sure you know who you're dealing with, and be wary because there's plenty of danger out there. Matt, I think I've gotten through my 30 minutes.
Sure. Thanks a lot, Jamie. What we'll do is we'll go ahead and we will open it up. If you have any sort of questions that you want to ask Jamie about sort of in this realm of understanding contracts, if there was something that he mentioned that you want a little bit more clarification on, feel free to drop that into the Q&A or into the chat, or you can raise your hand and we can allow you to ask that question. While some of those are coming in, Jamie, let me ask you a question, because unfortunately we all know that getting a good contract in place from the get-go is your best protection for all parties involved. But let's say that somebody here on this webinar is listening in and they're like, wow, I know now that I'm in a bad contract. You know, how do I get myself out of that? Do you have any sort of just general thoughts as ways to try to go about doing that?
Well, you know, again, it's probably a sliding scale based on the value of the contract. You know, if it is something that is of significant value, probably the first thing you want to do is consult with a lawyer. If this contract if staying in this contract could result in significant harm to your interest, then you need to consult with a lawyer. Now, if it doesn't, then you may consider just approaching the other side. Say, look, we made a mistake. We made a mistake entering this thing. Will you let us out of it? That's probably only should be done in circumstances where there's not very much at stake and you trust the other side. You have an ongoing relationship with the other side. There's a strong potential for continuing to do business with them. They may want to preserve the relationship. If you get the sense that that is the situation, that if the other side values your business and in this particular contract, they're likely to readily let you out of it, then you may try to do it informally. But if there's a significant amount at stake, you probably need to consult counsel.
Okay, thanks. Sarah asked a really good question. Says, can you explain what an indemnity clause is, and are they good or bad?
An indemnity is a clause that basically says one party to the agreement is going to protect the other party from damages that may arise from the execution of the service or the performance subject of the agreement. Give you an example. I'm dealing with one right now that involves an organization that is supporting another youth organization where the youth engage in various dangerous acts like swimming and you know, highlining and rappelling and that sort of thing. And the organization that's providing some support to this wants an indemnification from the other organization, protecting them from any liability that may arise from that organization's activity. So that's what an indemnity is.
Okay, great, thank you. Anna Grace asked in the chat, she says, can you please define consideration a little bit more, maybe give like another example of what consideration looks like when it comes to contracts? Sure.
In my email about the dollar per widget, $1 per 600 widgets, the dollar per widget's the consideration. The consideration flowing from the payor is the dollar, and the consideration flowing from the supplier is the widget. It is the thing that is exchanged. So the services can be consideration. Money is consideration. It's basically what one party conveys to the other party to get value from that other party.
Okay, I think that that's a really great summary of that, Anna Grace. Hopefully that helps give some clarification there. If you want to go ahead and drop some other questions, let's see, one just came in from Frank. This is a great question because I know we see this at times, even in local government, the contracts take a while. So Frank says, I submitted a contract in mid-February and have heard nothing from the bidder. What can or should I do now?
Well, you know, other factors being equal, more communication is always better than less communication. So I'd pick up the phone. I'd pick up the phone and find out what's going on. You know, that's what I would do. Now, if this is a public contract, then there's going to be there's a statute that says what has to happen if this is a public contract. By that I mean, if this is a city putting out a request for proposals, or a county putting out a request for proposals, then something is governing what's supposed to happen next. The statute governs it. And so, still communication could solve that problem. But in that case, it might be a little clearer because a statute may govern, or if it's a really large corporation, they may have a policy that governs. So you might look for any policies or statutes that govern.
Okay. Go ahead. Some more questions on here. Let's see. Mike just dropped one into the Q&A. What are some of the potential dangers of using standard forms you can buy in office stores?
Well, I mean, the dangers exist. I mean, I give you an example. This isn't technically a contract, but I saw an off-the-shelf human resources policy that said something to the effect of, I mean, I'm not kidding. This was probably 15, 20 years ago, but it said something to the effect of, the first time you harass somebody, you're going to be counseled. The second time you harass somebody, you're going to be disciplined in writing. And if you harass somebody a third time, then you're going to be subject to discipline up to termination. Well, I mean, that is so far out of the bounds of the law that, I mean, you could have an act of harassment that it warrants immediate firing. And that document came from a big supplier. It came from an HR company, I think, or someone who purported themselves as to be an HR company. And so you do have to be careful. Now, having said that, I've seen some of the documents from Zoom, LegalZoom, and I have to say, they can be pretty well done. You need to review the form contract to make sure it fits your circumstances, and that the services that are to be provided, or the goods that are to be provided, when they are to be provided, where they are to be provided, all that's clear in the contract. Those are generally material terms that have to be in the contract. So you got to be sure that that form contract addresses all that.
Okay. All right. If anybody has any other questions, feel free to drop them in the Q&A or the chat, or raise your hand. Jamie, let me ask one thing, because you do see this from time to time in contracts, where you come down and you talk about if it goes to some sort of litigation or arbitration, it actually has to go to a court. There's usually a definition of where the court is going to be located that hears the case. If you are sort of a home-based business and you're working with maybe a larger company, how much flexibility do you have, or do you have any flexibility to sort of try to have something happen here local to avoid you from maybe having to either get a lawyer that would be involved out of state, or you actually having to travel out of state and be engaged in that type of thing? Any thoughts along those lines?
That is a great question. I can't believe I didn't put that in my outline. That's a great question. And so here's the answer. For independent contractors, if you are contracting, an arm's length contract is one entity with another entity, and that entity might be Exxon or IBM, and the other entity may be Joe Smith, not even an entity, not even a legal entity. But if you are dealing as a contractor, you don't have any, you're going to have to abide by a clearly written venue provision. Now, if you are an employee, that is different. If you're an employee in Virginia, you're generally not going to sign a contract with an employer that requires you to litigate in California. Generally, you will litigate that in Virginia. But independent contractors, you are coming to the law, you are coming to the court in the exact same eyes as IBM, even if you're an individual. So, the court's going to look at you two exactly the same, and they're going to say, well, Joe Smith, you agreed to this. So does that answer it?
I think it does. I think it does. One of the last things, I know this has always been one of the interesting ones for me personally. Can you talk about use of the words would, should, shall, and when things become like really set in stone and when there's some flexibility? because
Yeah, another great,
because of those words, the usage of
another
those.
great question I should have had in the outline. May and should are not worth a damn. You know, will and shall are. So, you know, may and should and language like this is just way too squishy. It's not clear enough. You know, you will supply the widgets within 30 days. That's fairly clear. You shall supply the widgets within 30 days. That's clear. You should supply them is meaningless.
Yeah, that was always an interesting one for me to to come across in some different things that I've done. So,
Right.
all right, I am not seeing any other questions. If anybody has any last questions, you can drop them in there real quick. We can come back to them. I'm going to share my screen again just for a second here. Remind everybody that our next Lunch and Learn is going to be May 11th, again, starting at noon. Poquoson is going to be the locality host for that one. And the topic is going to be vertical IQ, database information designed to help small businesses succeed. The Small Business Development Center, Jim Carroll, his group are going to be the ones that can